Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today, in the series of company law, let us learn a new topic, the doctrine of constructive notice. In the previous video, we have learned about the doctrine of ultra vires. Let us move to the new topic, the doctrine of constructive notice, giving another more importance regarding the memorandum of association and articles of association. So as we all know that memorandum and articles of association are public documents. These are open to public as these are the documents which are submitted for the incorporation of the company. So these are obtained in the registrar of companies. So the memorandum contains the relationship between the company and the outsiders, and articles contain the constitution and internal management of the company. So what is this constructive notice? Constructive notice is nothing but because these memorandum of association and articles of association are public documents which are open to the public for inspection. These are available in the registrar of companies. After paying certain prescription fee, we get a copy of those. So any person who wants to contract with the company should have certain knowledge that he has read the memorandum, he has read the articles of association, he is having sound knowledge regarding these two documents. So this deemed knowledge is nothing but the constructive notice. Any person before contracting, he must make sure that his contract is consistent with these documents, and the person dealing with the company is bound by the law of estoppel, and he cannot be allowed to say that he had no actual notice of what are these contents in these documents. And the doctrine of constructive notice applies not only to the memorandum and articles but also other documents which have been filed with the registrar and with the special resolutions and particulars of the changes. So any kind of files which are obtained in the registrar of companies, not only memorandum and articles, any other documents which are filed along with these two documents by passing certain special resolutions and particular changes, these documents are also available in the registrar of companies, and the person should have certain knowledge. If he doesn't have certain knowledge, then he cannot be said that there is a breach of contract. So any contract which is inconsistent with these articles of association or inconsistent with the memorandum of articles of association will be null and void, and the basic knowledge of what is there inside these documents is nothing but the constructive notice. This doctrine is beautifully explained in a case law of Kotla Venkataswamy versus Murthy. In this case, the plaintiff, Kotla Venkataswamy, entered into an agreement with company to advance a loan. According to the articles of association of that company, 3 executives. Who are those executives? The managing director, the secretary, and the working director should sign the contract on behalf of the company. So in this instance, what happened is the mortgage deed was executed by the secretary and the working director only, and the managing director did not sign the mortgage deed. So on default of the payment by the company, the plaintiff, Kotla Venkataswamy, he sued the company for recovery of the mortgage debt. The company contended that mortgage deed was not executed properly because it was not signed by the managing director. So it is void. The plaintiff contended that he was not known about the condition mentioned in the articles of association, and he was not informed by the secretary and the working director that the managing director did not sign the mortgage deed, and it will become null and void. So the judgment was passed something like this. The court held that the articles of association and memorandum of association of a company are dealt as constructive notice, and it is the duty of any person who wants to make any contract should have a sound knowledge of these things. So it is the duty of the plaintiff to access and obtain the necessary copies of those public documents of that company, and then only he would have entered into contract with that company. As such, we have come to the end of the session. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe. Thank you.